All right, Kate, you want to introduce yourself and then get started?
Yeah, so hi everyone. My name is Katelyn Raycraft. I am a child protective service worker in Monongalia County, and today I am presenting the CPS processes. So starting out, centralized intake hotline. This is how the department receives concerns of or allegations of abuse or neglect. Um, It's just a number. I know that there are like billboards around at least Morgantown and I believe Fairmont as well. They're on the back of buses with the number of the hotline to call if anyone if anyone suspects abuse or neglect. Um, Mandated reporters are, of course, are required to call and report anything if they believe abuse or neglect to be occurring.
Um,
Um,
are you able to turn on your camera? Do you have a camera that you could turn on? It's just helpful if we can see the presenter, if that's possible.
my camera is not working.
Okay, well then it's not that fault.
Sorry. Yeah. Um, Sorry. There is specific criteria that needs to be met for a referral to either be screened in or screened out. I pulled this directly from CPS policy for what would be accepted and what would be screened out. Um, it says so child protective services must accept for assessment any report which suggests that, assuming the reporter's perceptions are true, an individual between birth and 18 years old may have been subject to treatment which meets the definition of abuse or neglect in West Virginia Code and CPS policy. A reporter need not have witnessed a specific injury, nor does there have to be an injury for there to be a reason to believe that parental conduct results in a threat of harm to a child, which is included in the statutory definitions of an abused and neglected child? And then reasons for a referral being screened out. It could be a duplicate referral during initial assessment. These are typically if a worker already has a referral on a family, um, and they are assessing for those same allegations. A new referral might be screened out. Information does not meet the legal definition of abused or neglected child found in West Virginia. There's insufficient information to locate the family. There are no children under 18, and the family does not reside in West Virginia. If a referral is accepted, then a worker in the county of incident will be assigned. Next, I wanted to talk about referrals. One of the most popular phrases you may hear workers say is the department received a referral. This is just common language that is used for a report of abuse or neglect. Once a referral is accepted and assigned to a worker, the worker must see the target child within 72 hours of receiving that referral, unless the maltreatment is occurring now. In those cases, the worker must immediately respond. The target child is the child in which the maltreatment is being alleged that is happening to them. If there's a sibling set of four, there might only be one child that is the target child, um, but the worker would still have to see all of the children. But that target child would need to be the first child that they speak with. There are other specific cases where timeframes may look different. For referrals solely of educational neglect, the time frame may be a 14-day response. The worker would have 14 days to see that child before missing the time frame. In instances where there is a drug affected infant, the referral will come in as a 0 to 24-hour response. So, initiating the assessment. Once the referral is assigned, the worker will begin to gather necessary information on the family, such as any CPS history and any relevant information, an address, a date of birth, correct names, and anything else that the worker may feel is pertinent to finding or locating the family. After the information is gathered, the worker will go out and attempt to make contact with the family. If the family's not home, the worker will leave their business card in the door for the family to reach back out, and the worker should be attempting the home daily until that contact can be made with the family. The worker will talk to every member of the family that lives in the home to determine if there are any impending dangers or safety threats present. Each family member should be talked to separately in a private area of the home. The worker will get additional information for collaterals. Collaterals are just people who know the family well, who interact with the family, who can talk about the family dynamic. Other good collaterals that could be used are the pediatrician, daycare, law enforcement, any community services that may be working with the family already, such as birth to three, early head start, right from the start. A lot of times, collaterals that are given um, are family friends or family members, and sometimes it's good to get a neutral outside perspective if that child attends daycare or if they are working with community services. So, next steps. If no abuse or neglect has been identified, the worker will type up the assessment after talking with all family members and collaterals. The worker will then submit this assessment and the case will be closed out. Um, After the case is closed out, the department has no further involvement with that family. If abuse or neglect has been identified during the assessment, then there are a few next steps that the worker must take to ensure safety of the child or children. The worker will staff the case with their supervisor and a prosecutor if necessary. And during these staffings, the worker will relay all information that they have learned while speaking with the family. Um, and it will be discussed whether safety can be maintained in the home or if another route needs to be taken. And this brings us to ongoing cases. So, after the initial assessment is complete, the case will become an ongoing case. These cases are considered ongoing when abuse or neglect was found and CPS intervention was necessary. There are two types of ongoing cases: an in home case and an out of home case. An in home case is a case where the child or children remain in their home during the length of the CPS involvement. Um, they can be in their home through a temporary protection plan, a safety plan, or sometimes through a petition filed through the court. So, a temporary protection plan is a 7-day plan that allows for the safety of the child or children when an immediate safety threat is identified. This plan is implemented to allow the worker more time to assess and gather more information. And after the 7 days, the plan will expire and the worker will need to discuss with their supervisor how to proceed. Um, and a safety plan is a 90-day plan that is implemented to help control and maintain safety of the child or children. Safety plans should be in depth and clearly identify how safety is being maintained, what services will be provided to the family, and how those services will help contribute to overcoming the problem or situation that led to CPS intervention. These plans will include safety resources, services, and linking the family to community resources. A plan can be changed or altered at any point during the 90 days, and the safety resources can be informal by using family and friends. However, the worker should gather information about the safety resources to ensure that they are a safe person and appropriate to put on the plan. Um, And then during the cases where a petition is filed, a safety plan will still be implemented to maintain safety. The safety will be implemented with the non-offending parent, but both parents should be aware and agreeable to the safety plan. There are always, different cases where a parent may not agree to the safety plan or refuse to sign the safety plan, but they should still be fully informed of the plan. So I have listed a couple scenarios where an in-home case might begin. Um, so the first one is if a worker goes out to the home and the home is cluttered and unsafe for the child that is living in the home, a worker can implement a temporary protection plan. This plan allows for the family to clean up the home and clear up any safety concerns that were present, um, such as, there were chemicals that were spilled on the floor, or there were, if the child is an infant or a toddler and there were food all over the floor and it was just an unsafe environment. This will give that family some time to get the home cleaned up. And after the 7 days, the worker can go back out to the home to ensure that there are no impending dangers or safety threats present. And if there are none, then the 7 day plan will lapse and the worker will close out the assessment as normal. Um, the if the family during the 7 days, if the family can, gets the home cleaned up within 3 days, and that home is now appropriate for the child to return, then the child can do so, and the plan can lapse and not go any further. But the maximum amount of time is 7 days for a temporary protection plan. In cases where there are allegations of sexual abuse, physical abuse, domestic violence, or another immediate safety concern, these can vary from case to case. The worker can implement a temporary protection plan to allow more time to assess the situation. These plans typically look different than the plan where a child is unsafe for in a home where it is cluttered. These plans typically are more in-depth plans of figuring out how to proceed when there are allegations of sexual abuse, talking with family members, law enforcement, the prosecutor, and discussing whether or not a forensic interview is necessary when there are allegations of physical, sexual, domestic violence. In these situations, if the allegations are unfounded, the case may be closed out as normal. In a situation where there are disclosures during that 7 day plan, it's important to figure out the next steps of how to proceed, talking with your supervisor and the prosecutor of what to do next. And then in cases where there are disclosures or observations by the worker of substance use by one parent, a temporary protection plan can be implemented to allow that parent to drug screen at day report, and it gives the worker and the family more time to figure out how to proceed. If the other parent was unaware of the substance use, the parents may be talking together to have the one parent go to treatment, and figuring out like what their next steps will be while we continue to assess. Out of home cases. So, out of home cases are ongoing cases where it is unsafe for a child or children to remain in their home during the length of the CPS involvement. This occurs when the safety cannot be maintained and the department might take custody of the child or children. And there are two ways in which the department will seek custody: a ratification or through a petition. So, what is commonly referred to as a ratification consists of two documents: the application for ratifying emergency custody and the order with respect to the application. and a ratification is necessary when there is imminent danger and the worker needs to act now. These situations can vary, but the facts come down to, is the child safe? And if the child, and will this child continue to be unsafe once the worker leaves the home? So the ratification are filled out by the worker. They will put the name of the family, the address, and the reason for removal. Um, the ratification is signed by the worker before appearing in front of the circuit court judge. The judge will swear in the worker before hearing a brief summary of why a removal is necessary in this instance. The department can take custody before the ratification is signed. However, once the ratification is signed by the worker and the judge, the department has custody for 48 judicial hours until a petition is filed. And once that ratification is signed, the petition that is filed is an emergency petition. So the emergency petition is a detailed summary of everything that has occurred since the department first received the referral. It will outline any CPS or criminal history that is relevant to the case. The petition will list the allegations that are being alleged against the parents. And once that emergency petition is filed, a preliminary hearing will occur within 10 days of it being filed. The parents will get a copy of the petition and will be appointed attorneys. The children will be appointed a GAL or guardian ad litem. And once that petition is signed by the judge, the department will be granted temporary physical and legal custody of the children. So the ratification is only good for the 48 judicial hours. And then once that petition is filed, the department is granted temporary physical and legal custody of the children through the remainder of the case. So in situations where an emergency petition is not necessary, but court involvement is necessary, they are outlined the same as an emergency petition, but once filed, they operate a little differently. Instead of a preliminary hearing being within 10 days, it is an adjudication hearing that is held within 30 days of the filing of the petition. So ongoing case monitoring. Regardless of whether the case is in home or out of home, the workers are responsible for having good communication and following up with the family. Children in any open case should be seen regularly. Children that are placed in kinship or fictive kin homes or a residential placement should be seen monthly. Children placed in a foster home through an agency can be seen every 3 months, but the worker should be following up with the agency and talking with that agency's worker to make sure that that everything is going well in the home, the child is getting everything they need, and there are no concerns. Ongoing monitoring with an in-home case requires the worker to follow up with service providers, safety resources, and the family to ensure they are following the plan and getting the services they need to address the safety concerns. Whereas an out-of-home case requires a little bit more management as there are more players involved with the attorneys, the GAL, the worker, the foster parents, the foster agency. It's important to make sure that you are kind of keep following along with all of those people and making sure that everybody is a part of the case and know what's going on. So once that petition is filed, a multidisciplinary treatment team meeting should be scheduled within 30 days of the petition being filed. So these are meetings where all of the players will meet. It can be in person or over Google Meets, but these meetings are to discuss progress and barriers in the case. And the meeting should include the prosecutor, the attorneys, the GAL, CASA, parents, foster parents, and any service providers that are working with the family, and then, of course, the worker. And in these meetings, it is essentially everyone meeting and talking except for the judge. So this kind of gives everybody a chance to talk about, what's going great in the case or any possible barriers that the family may be having and how these can be fixed to ensure that the case continues to progress and the parents are doing what they need to be doing. And if they have any questions, they can ask in these meetings. The worker should ensure that the family is set up with all the necessary services and treatment that is recommended through the MDT, the court, if it's an out-of-home case, and the psychological evaluation if that is completed in the case. These are vital aspects for the case to continue its progress. And the worker should be reaching out to the family, regardless of it being in home or out of home, to make sure that these services are working with the family, that the family is participating in these services and not just showing up and doing what they need to do just to get the services done, that they are participating and being a part of those services. So kind of going to abuse and neglect proceedings, I know I talked about the petitions being filed and preliminary hearings, adjudication hearings in the out-of-home case slide, but kind of going back to those and talking more about them. So when an emergency petition is filed, the preliminary hearing occurs within 10 days of it being filed. This is a probable cause hearing, essentially to determine whether or not the department acted appropriately in removing the children. So after the preliminary hearing, if probable cause is found, then the next hearing is the adjudication hearing. Within 30 days, and this occurs within 30 days of the preliminary hearing or the non-emergency general petition being filed. This hearing is whether the department has clear and convincing evidence that abuse or neglect has occurred in the case. After the adjudication hearing is the disposition hearing. This is a more complex hearing to get to, and it typically occurs more so at the end of the case, and that there are a few different dispositions that are available, and I will talk about this in the next two slides. So I have here a diagram of abuse and neglect proceedings. I apologize, it's a little bit hard to read, but I know that this is a lot of information. It can be confusing with emergency, non-emergency, and what happens next. So this diagram kind of helps show what to expect and what happens next. So it has the emergency petition, and then within 10 days, the preliminary hearing, within 30 days, the adjudication hearing, and then the red box is the disposition hearing. And the other boxes that are surrounding those are possible improvement periods that the parents can be granted during the case. So the improvement periods. So after the preliminary hearing and before the adjudication hearing, a parent might be granted a pre-adjudicatory improvement period. This is good for a maximum of 3 months. And a review is set up if the parent successfully completes the improvement period. At that review hearing, they are dismissed as a respondent and are changed to an interested party in the case. If they do not successfully complete the improvement period, then they must show substantial change in circumstances to be granted any other improvement period throughout the case. So for the pre-adjudicatory improvement period, it is essentially 3 months to, change what led to the filing of the petition. And it is such a short amount of time to try to complete everything that is needed and get everything done in those 3 months. So after the adjudication hearing, a parent can be granted a post-adjudicatory improvement period. This is an improvement period that is good for a maximum of 6 months. And during these improvement periods, the parent is required to follow specific terms and conditions put into place by the MDT in the court. Some of these terms and conditions can be to maintain employment, maintain housing, fully participate in a psychological evaluation, and following the recommendations of that evaluation. If substance abuse is an issue in that case, following and completing a substance abuse treatment program, participating in random drug screens, participating in any services that are implemented, attending all court hearings, participating in the MDT process. Those are all things that are expected during a post-adjudicatory improvement period. So after the post-adjudicatory improvement period is complete in those 6 months, then a disposition hearing will be held where the parent can be granted a post-dispositional improvement period. This is good for another 6 months, and the parent is required to continue following the same specific terms and conditions that were previously ordered during the post-adjudicatory improvement period. And there are extensions to the post-adjudicatory improvement and the post-dispositional that can be granted for an additional 6 months overall. So 3 for the post-adjudicatory and 3 for post-dispositional. So dispositions. So after all of the improvement periods, and the disposition hearing, if they are granted a post-dispositional improvement period, we get to the disposition. So at that disposition hearing, there are a few options available depending on how the parents have adequately participated throughout the case. Some are more commonly used than others. If the parents have successfully completed their improvement period and the safety threats no longer exist, the case may be dismissed with services or without services. And then if a parent does not successfully complete an improvement period and the issues that led to the filing of the petition are unlikely to be remedied in the near future, then their parental rights may be terminated. Other dispositions that may be available are a Disposition 5, temporary legal guardianship, and supervision through the department continues. So termination versus reunification. So during a case, if a parent chooses to, they can voluntarily relinquish their rights to the child or children. Their rights will be terminated, but through a voluntary relinquishment. So if their circumstances change and they have more children in the future, the relinquishment can be looked at. If the parent is involuntarily terminated, then their rights to the child or children are terminated, and if they have more children in the future, then CPS will be involved through a petition. This doesn't always mean that the department will seek custody of that child in the future, but a petition will be filed. A disposition 5 is essentially a parent putting their rights on hold until they are able to change the circumstances and file to amend their disposition in the future. This disposition is typically used in cases where the child's other parent successfully completes or is an interested party to the case, and permanency can be achieved with that child with their other biological parent. If parental rights are terminated to both parents, then the child becomes a state ward and can be adopted at that time. So reunification. So if the parent successfully completes and is participating, then reunification may begin. So reunification is always the goal unless aggravated circumstances apply. So there are 7 kinds of aggravated circumstances, and they are if the child's parent, guardian, or custodian commits murder of another parent or child, committed voluntary manslaughter, attempted or conspired to commit murder or voluntary manslaughter, committed unlawful or malicious wounding that resulted in serious bodily injury to the child, parent, guardian, custodian, or to another child residing in the home, committed sexual abuse of the child's other parent, another child residing in the home, has been required by the state of federal law to register with a sex offender registry, and the court determined based on the circumstances that the child's interests would not be promoted by a preservation of the family, or parental rights of another child are involuntarily terminated. And those are the 7 kinds of aggravated circumstances where reunification may not be the goal. So the timeline of reunification will look different with every case. When a parent is participating and the MDT and court believe it is appropriate, trial reunification may begin. The children will remain in the department's custody but are able to be at home with their parent or parents while continuing to participate in the case and services. Trial unification starts slowly by having longer visits, then overnight visits, and eventually weekend, and then in the home full time. During this transition period, services will remain in place and pop-ins and supervision at the home are likely. Once a family is successfully reunified, the case may be dismissed with services. This will turn the case into an in-home case where a safety plan is implemented for 90 days. Service providers offer reunification services that can be used. During this time, it's important that the worker stay in contact with the family to ensure things are going smoothly. After the 90 days, the plan will be reassessed and the case may be closed out. And then once the case is closed out and reunification has occurred, the department no longer has any involvement. So, ending CPS involvement. If a family completes all necessary intervention, their case will be closed out, and then all documents, progress reports, contacts, and court orders will be uploaded into their case. Once that case is closed out, in order to be involved with the family again, a new referral alleging abuse or neglect must be accepted for assignment. Otherwise, the department will discontinue all involvement with the family. And once we are out, we are out. And so thank you for your time and listening to my presentation. Any questions, comments, or concerns?
Hi, Katelyn. This is Anna. I had a quick question. So relapses are pretty common with recovery, as you probably know. So I was just wondering, is there a standard approach to deal with those, or are the children always removed and the process starts over?
So no, not always.